I would call attention first to the addition to Rule 19703B, which is described on page 6 of the report. It's intended to make more feasible a restorative approach to attorney misconduct that arises more from stressors and inexperience, than willful malevolence. There was a lot of discussion in subcommittee about the importance of this and in the Rules Committee itself, trying to identify resources that can help an attorney deal with issues that brought the attorney before Bar Council. That kind of thing can fit very nicely with peer review process, with conditional diversion agreements, with dismissals with cautionary advice or admonition. Bar Council has supported that provision. Second is a splitting of the current dismissal with a warning into dismissals accompanied by a letter of cautionary advice or an admonition, which is described on page 8 of the report. And finally, with respect to my summary, is the issue of Attorney Grievance Commission organizational depositions, which is referred to on page 8. This was before the court a year or two ago, and the court deferred on it. And we've raised it again because it was raised again with us. And with respect, it would be helpful if the court would deal with that issue one way or the other. Now, I do want to address Mr. Kramer's, and by proxy, Mr. Hines's comment. Mr. Kramer and Mr. Hines, who frequently represent attorneys before Bar Council and the AGC, complained before our attorney subcommittee and complained before the Full Rules Committee, and now complain before the court that the attorney grievance procedure is unconscionably unfair to lawyers who are charged with misconduct, that it lacks transparency, that it is rife with forbidden ex parte communications, and that the commission too often rejects recommendations from peer review committees that favor the attorney. As a general response, their complaint to the court, as it was to the committee, I suggest is long on rhetoric, but short on supporting facts. It's 91 pages in length, and in large part is a collection of unsupported assertions that were denied by Bar Council and by others who have dealt with Bar Council. Before the Rules Committee, they argued, one, that the circuit judge designated by this court to hold an evidentiary hearing should have the authority to dismiss charges as a matter of law or grant summary judgment in favor of the attorney. That was their position. Two, that Bar Council should have no authority to object to a recommendation of a peer review panel that is favorable to the attorney. Three, that if the AGC disagrees with a peer review panel recommendation, it should be required to give written reasons why. And four, that there should be structured diversion programs that include mandatory CLE and community service as a form of punishment. Taking these in turn, first, as to whether the circuit judge should have the power to dismiss the petition on motion, the court has made this abundantly clear that that is not jurisdictionally so. The court is the one that, this court is the one that has exclusive original jurisdiction over these cases, and that the circuit judge is there for one reason and one reason only, and that is to take evidence, make proposed findings of fact, and propose conclusions of law. They have no jurisdiction to dismiss a case. That is something that only the Court of Appeals can do, and that includes granting summary judgments. Now, before the court, they backed off a little on that. They now want the circuit judge on an attorney's motion to bifurcate the proceeding, not to do what the court directed them to do, but instead transmit conclusions of law that recite grounds for summary judgment, which the Court of Appeals can then accept or reject. There would be no fact-finding by the judge, only his or her memorandum supporting the dismissal or summary judgment, coupled by briefs and oral argument in this court. Under their proposal, if the court rejects the judge's proposed dismissal or summary judgment, the case would go back for what it was sent there in the first place, an evidentiary hearing. Wasted would be all that the circuit court judge did and the whole proceeding before this court. We suggest that that is wholly inconsistent with the role of the circuit judge and would inevitably delay the administrative consideration of the charges by the circuit court judge, which under the rule must be completed within 120 days. In the scorched earth practice that typifies some of these cases, not all, thank goodness, the judge would be beset with motions to dismiss, followed by motions for summary judgment, all based on affidavits rather than live testimony, and endless arguments that by law are reserved for this court alone to resolve. The current system about which they complain was put in place by this court in the year 2000 in order to address the court's massive dissatisfaction with the long delays in resolving complaints against attorneys, sometimes delays as long as 4 to 6 years from the time that the complaint was filed, and all due to the roadblocks that were part of the system it replaced. What Mr. Kramer and Mr. Hine want is not only inconsistent with the limited role of the circuit judge, but would recreate the very prospective delays that the court found unacceptable in 2000. Nor is that necessary. Under the current system, after hearing evidence and considering argument, the circuit judge could find in his or her report that there was insufficient evidence presented to show a charged violation. Bar counsel could then file an exception and the Court of Appeals could rule on it. But that conclusion by the judge and any ruling by this court would be based on a full evidentiary record, not just a bunch of affidavits. Second, with respect to the peer review panel recommendation, the end result of the peer review process is a recommendation by the panel to AGC. The recommendation has no presumption of correctness and is not based on any evidentiary hearing. It is nothing more than an independent view of the panel regarding an appropriate disposition based on the complaint, any response by the attorney, and informal discussions with the attorney and bar counsel that are strictly confidential. If bar counsel and the attorney agree on the recommendation, it goes to AGC as an agreed recommendation. If either party does not agree, it goes to AGC as an independent panel recommendation in which a non-agreeing party can object. Mr. Kramer and Mr. Hine want to preclude bar counsel, but not the attorney, from objecting to a panel recommendation. The committee voted to retain the present approach and keep the playing field level. Now, where this sometimes plays out is when the panel recommends a conditional diversion agreement and bar counsel does not believe that the case is a proper one for such an agreement. It may be because she finds there would be a problem implementing or monitoring it. It may be because she believes the misconduct requires a more significant sanction because of the nature of the conduct or because it's repetitive. What Mr. Kramer and Mr. Hine want is to force bar counsel to agree to the panel recommendation if it's favorable to the attorney. The committee decided not to do that and recommends that the court not tie bar counsel's hands in that situation. Bar counsel's ability to object to a panel recommendation is important. These recommendations, as I say, are not sacrosanct. In 2020, the commission rejected 10 recommendations from review panel that resulted in greater disciplinary exposure for the attorney. Third, they want to require when AGC rejects a panel recommendation that AGC state its reasons for doing so in writing. At that point, all the AGC has is a statement of charges, a response from the attorney, and a recommendation based on a non-adjudicative confidential conference. Requiring AGC to disclose in writing its thought processes regarding a proposed disposition before it has heard any evidence would be wholly inappropriate. Finally, with respect to the approval of Bar Council, amendments to the rule in 19702 will set the stage for restorative measures to be identified and made available when appropriate. It is not appropriate, we think, to build into AGC rules global CLE as recommended by Mr. Kramer and Mr. Hine. That is a separate issue that this court, the Rules Committee, and the MSBA have wrestled with for decades, and it doesn't belong here. As for community service as some kind of a punishment, which is also included in their comment, through conditional diversion agreements and dispositions by this court, a whole variety of remedial measures can be applied as appropriate in individual cases. We don't need a rule on community service any more than a rule on anger management or marriage counseling. Now, is the system broke from the perspective of the attorney? Look at the statistics and the annual report of the AGC and the court's own docket. Complaints received last year, 1,451. Complaints docketed, 253, an 82% washout. Closed or dismissed, 144, 43% washout of what remained. Of those, 38 were reprimands, 64 disbarments, 13 indefinite suspensions. We don't believe that the system is broke. And I guess one of the clear statistics is that of the cases that reached this court in which the attorney was disciplined, 31 were on joint petition. The current rules have been in effect for 20 years. It says something that given the caseload, given all the attorneys that have been before Bar Council and this court, only one lawyer, Mr. Kramer, and by proxy, Mr. Hine, have filed a complaint about it. I'm happy to answer any questions. We think that the rules that were proposed with the consent of AGC, with the consent of Bar Council, and with the approval of the lawyers on the Rules Committee, we think they all should be adopted.
Mr. Kramer, who is here, and as with all other speakers, I know you would adhere to the 5-minute rule. You may proceed.
Thank you, Your Honor. May it please the court. I don't get equal time, and I don't have the time to rebut what I believe to be some misstatements respecting the proposals that Mr. Hine put forth and that were never actually put on the agenda of the subcommittee or the Rules Committee as a whole. I would urge this court, as stewards of our profession, to read through what I've submitted in writing very carefully and draw your own conclusions about what has been proposed. Because unfortunately, I don't believe that too many members of the subcommittee or committee as a whole ever gave it that opportunity. As stewards of our profession, you've been given an unprecedented opportunity to improve our profession, but very limited time to do it. And I would suggest that we start with our approach to lawyers in crisis. So in my limited time, I need to focus on shortcomings of what I believe to be a one-dimensional approach to our profession's most serious problems: mental illness, addiction, depression, anxiety, suicide, higher incidence than the population at large. The lack of business acumen for attorneys who, they pretty good lawyers, but they just don't have quite the experience to manage practices, and that leads to a number of problems. And ironically, that problem is experienced more for those who serve the underserved and do low bono work without the resources of larger firms and have a larger volume that they've got to cope with. This court is always saying that the purpose of discipline is to protect the public, not to punish the errant attorney. But the only approach we've really considered in Maryland is punishment. If we're serious about protecting members of the public, we must take greater care with the lives of those who serve them. Unlike most other states, and I wish I had time to go through state by state with you, Maryland's rules only provide for ad hoc CDAs that leave the rehabilitation of lawyers to the person charged with their prosecution. Without Bar Counsel's approval, the rules do not permit a peer review panel to recommend a CDA. And even the commission lacks the power to order one over Bar Counsel's objection. This is far too important to leave to the unfettered discretion of a single official. We need to do more. We need structured diversionary plans that have 4 components. Continuing legal education. We know that proposals for CLE, mandatory CLE, haven't flown. But in this case, we would put CLE where it's needed the most, on lawyers who will regard it as an opportunity, not as an imposition. Addiction and crisis intervention. The State Bar, Maryland State Bar Association, has an excellent program for lawyer assistance. The problem is it's underutilized. We can do better. Mentorship, community service. Let's let lawyers work off some of those sanctions that they might otherwise be reprimanded for. We're always talking about serving the underserved, but we can do something about it. There's nothing wrong with that. Community service is a component of many rehabilitation plans throughout our legal system. Why not here? The State Bar Association has really embraced what we have proposed in this regard. And we can even get creative. What about IALTA amnesty? I'll bet you if we were to audit a large percentage of IALTA accounts in this state, we would find most of them out of compliance. Why not, if we want to really protect the public and not punish lawyers, why don't we give amnesty so lawyers who've lost track of their accounts can maybe get it back? I'm talking to the brightest legal minds in the state of Maryland. Surely we can do better than just look at punishment and punishment alone. We need a work group to consider these proposals, to really dig in. Because I can assure you, having been a member of the Rules Committee and having seen the subcommittee process and being a member of the subcommittee, we have not done that job. This job is simply too important. And throughout the state, wherever I have gone, there's only been one member of the bar who has refused to meet with me to discuss these proposals. I would ask of all 7 of you that you take a very strong look at this, because the future of our profession and the health of our profession depend on it.
All right, thank you, Mr. Kramer.
I just have one question. Chief
Please, Judge Getty.
So with regard to Mr. Kramer's testimony, towards the end, he sort of made a plea that some of what's contained in his testimony would be of value in maybe a separate study committee or a subcommittee of the rules to look at some of his proposals. Ms. Lawless, are there some proposals there that you think need further study?
There are not, Judge Getty. The rules are really set up in a really comprehensive way to deal with the issues of not just mental health and substance abuse, but as this court has seen, an increase in diminished capacity cases. Some of the rule revisions in these proposals are really aimed at that. The 19707 revision allows for the commission and bar council to make an affirmative disclosure early on in the investigation to a lawyer's assistance program. We have these cases where we know that there may be a mental health or substance abuse issue, and our hands are tied by our confidentiality rules. That allows for sort of early intervention. The conditional diversion agreements are not ad hoc. They are specifically tailored to an individual respondent attorney's needs. They are good, they are successful. We work very well. We work with the lawyer assistance program routinely. We have great volunteer lawyers that will work as monitors. We have in-house trust account training. Our investigator has developed a program. And then some of the other rules that are before this court give some teeth to the tools that we already had. For example, subpoena power to compel a mental health evaluation during the investigative stage, because sometimes what happens in these cases is where there may be a mental health or substance abuse issue, and we're precluded from investigating because we currently don't have that subpoena power. We're forced to charge misconduct and sort of go forward on a misconduct trail when really we should be investigating it for incapacity. So the new subpoena rule certainly provides for that. And then there's teeth to the failure to cooperate. There's a provision by which circuit courts can appoint an attorney for a respondent attorney where there are incapacity rules and new provisions for the payment of those attorneys. And so I think that the rules were good as they existed. I think the conditional diversion agreement program works. I think that some of the changes that are before this court will address any of the other issues. I am acutely aware of the mental health and substance abuse issues that face the bar, as is the commission. We are extremely sensitive to those issues and diminished capacity issues and treat them with the care and respect that the rules provide. They can be treated.
Thank you.
We'll hear now from Linda Lamone.
Thank you very much, Your Honor. May it please the court, Linda Lamone, Chair of the Commission. I just want to second everything that Lydia just said to you. The Commission welcomes the very thoughtful changes that the Rules Committee is recommending to the court. And we are indeed acutely aware of the issues that Mr. Kramer raised, and have great confidence in Bar Counsel and her very competent staff to deal with these matters, and appreciate the opportunity to be here this afternoon, and urge that you adopt the Rules Committee recommendations. Thank you.